Okay, sir.
Ms. Rivera, you ready?
Yes, sir.
All right. At this time, the court will call case number 653-875, State of Texas versus Joshua Garapula. Jesse Sanchez, you ready?
Yes, we are, Judge.
State.
Yes, Your Honor.
All right. Mr. Garapula, would you please raise your right hand? You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Thank you, sir. You may put your hand down. How do you pronounce your last name yourself?
It's Garafola.
Garafola. Okay.
Yes.
Mr. Garafola, before we proceed any further, the first thing I have to do is visit with you and make sure that you are fully aware of certain constitutional rights and protections that you have. The first right I want to discuss is the right to remain silent. Under our constitutional laws, you have the right to not have to make any kind of statements. You have the right that you do not have to answer questions. You do not have to submit paperwork with your signature, especially papers that admit or confess to wrongdoing. That's essentially the right to remain silent. You understand you have that right?
Yes.
You have the right to a jury trial. That is where you and your attorney and the state's attorney would select 6 people from a random jury pool from our community. And those 6 people selected would hear the testimony, the evidence, materials, whatever, and then decide whether you're guilty or not guilty. That's the right to a jury trial. You understand you have that right?
Yes.
In a jury trial, people will testify, and you have the right to cross-examine, challenge, or question any witness who would testify. That's called the right to confront witnesses, also known as the right to face your accusers. You understand you have that right?
Yes, I do.
There's another right called the right to appeal. That right you can exercise yourself. Your attorney can exercise by himself or the 2 of you together. That right, you have to use the correct paperwork and stay within the legal time limits allowed by law. That right is a right where you can demand that a higher court review the official record in this proceeding, review the evidence, whatever, and for whatever challenge you wanted to make. That right is basically the right to appeal. You understand you have that right?
Yes.
Finally, there's a right to demand that this matter, this hearing and proceedings be held in the open public courtroom. Because of the pandemic, the COVID pandemic, we've not been doing that. Hopefully we're doing it in the future. We're trying to do it. But bottom line, the law requires that you can demand rather that this hearing and process be done in the open public courtroom. Instead of doing it that way, we're doing it by, as you know, virtually or by Zoom. And this is being streamed on YouTube so that anyone that wants to can tune in and see and hear you and everything else and everybody that's involved in this proceeding. That's called the right to have an open public courtroom proceeding. That right and all the other rights that I just mentioned, you're giving up those rights at this time in order to proceed in this hearing. Do you understand that?
Yes, I do.
All right. Now I'm going to show you some paperwork. These are documents from this case, and these documents are essential to this case. They will all start, with one exception, they will start at the top with what I call identifying information. When we get a new document, you'll find this repeated. The case number, which is 653-875, the State of Texas versus Joshua Brandon Garafola. in County Court at Law Number 5, Bexar County, Texas. That's the identifying information. Then it's got the title to the particular document, all in all capitals in bold print. This one says state's consent to video conference. I mentioned a while ago that you and the state have the right to demand a hearing in the public courtroom. They have that right just like you do. It's an individual right for the state and defense. You have seen this document and reviewed it.
Yes, I have.
You'll notice that Ms. Caitlin C. Morgan signed on behalf of the state that they agreed to the video conference. Now, the document you're looking at now is called a discovery acknowledgement. Again, at the top, identifying information is repeated. There is the very first line of this document under the title. It says, pursuant to Article 39.14 of the Code of Criminal Procedure. That's a particular law in Texas that requires the state prosecutors, the government prosecutors, to share with, acknowledge, or provide access to all the relevant evidence and materials, receipts, books, videos, whatever it is. They have to make that open to you. This particular document is signed by your attorney and the state's attorney. They are declaring in the public record that in this case, that law has been obeyed. You understand that?
Yes.
All right. Now we have the third document is defendant's consent to video conference. Since you have the right to demand this be done in the public courtroom, we're getting around that by your consenting, and you have signed this, and so has your attorney, to do this in the video conference. Is that correct?
Yes.
All right, now we have another document. This one has the repeats the identifying information. Then it says defendants, the title of the document, defendant's waiver of constitutional rights and court's admonition. The very first sentence says that you don't need me to read to you word for word the document that accuses you. The second sentence, they're all separated. The second sentence says, hey, I know what I'm charged with. I was originally arrested and charged with DWI with a blood alcohol content of 0.15 or higher, also commonly known as being arrested for extreme intoxication. And this third sentence says, I am pleading nolo contendere, that is you are, to DWI. Now, right away, as the judge right away, it tells me that this has been changed from the original charge to a DWI first, or also known as DWI misdemeanor B. Did you see and understand that?
Yes.
What does that sentence say? Read that for me, that particular one.
Which sentence? Sentence number one?
The one at the top, right there, above number one.
In this case, I hereby enter a plea of no contest to the following allegations, DWI.
Very good. Mr. Sanchez, did you and your client carefully review this entire document?
Yes, Your Honor.
Mr. Garafola, the rest of this document is divided into 15 numbered parts. This first, number one, talks about the kinds of punishment for different offenses. And it has a vertical stack of boxes. Next to each box is a particular type of sentence for whatever the crime is. The very first box is the only one checked in the whole bunch, right?
Yes.
And it tells you that the sentence for DWI is the range of sentences anywhere from $0 fine to $2,000 fine, and jail from a minimum 72 hours to 180 days in jail. Did you see and understand that?
Yes, I do.
All right. Now, your attorney has said that you two have reviewed all of these 15 paragraphs or parts. Did you, in fact, review this and understand it?
I did.
Do you have any questions?
Not at this moment.
Have you ever been involved with a sex offender program at all?
Never.
Good. And where were you born, sir?
Reno, Nevada.
That makes you a U.S. citizen, and the papers in this case will so reflect. I
Correct.
need to remind you of a couple of essential things. One is the deal that was made with you and for you with the state. That deal, as the judge, I have to say whether it's going to be okay or acceptable or not. It is my authority and my responsibility to say yes, we accept the deal, and no, I reject it as the judge. I also have the authority to give you any punishment within the range of punishment we just talked about for DWI, even if I give you a punishment that's heavier than what you agreed to. However, if I reject your deal, or if I give you a punishment that's greater than what you agreed to, then in that case, the law would allow you to start all over again. And nothing that you've said or anything that you've done or signed, rather, would be used against you. Is that clear?
Yes, it is, Your Honor.
All right. And you signed this document, right?
Correct.
Okay. Now, the next document we're showing you, this one is mine, where as the judge, I certify to you that you don't have a right of appeal. There's a stack of vertical stack of boxes. Next to each box is a declaration concerning a right of appeal. The fifth one, which is at the top right now, has been moved there so you can see it. That box will be marked, and it says this is a plea bargain case, and you do not have any right of appeal. Do you understand that?
I do.
And by the way, in the right of appeal, when I described it earlier, I said that you could get a higher court to review the official record. That official record is being prepared by a certified court reporter, and that's Mrs. Kaylin Rivera. So there is such a thing. There's no question that you're aware of that. Is that correct?
Yes.
All right. The certification of the right of appeal, I have just told you that. I certify that. I will be signing that in the official papers. You have any question about that?
Not right now. I do not, Your Honor.
Okay, now we're getting to another critical part. Again, the repetition of the identifying information. This document is called Application for Deferred Adjudication. First question, you and Mr. Sanchez, did you both review this document carefully?
I did.
Mr. Sanchez,
Yes, Your Honor.
you reviewed it with him.
Yes, I did.
All right. I want to review or remind you of a couple of essential things, Mr. Garofalo. In regular probation, you enter a plea and you're found guilty. And then the sentence portions of it, mainly the jail sentence, is probated or suspended. But you're found guilty. In deferred adjudication, your attorney has gotten you the best of the probation in that, first of all, I will not find you guilty, even though a nolo contendere plea is considered a guilty plea. I will not find you guilty. Instead, I'm going to place you on deferred adjudication. Those are big words. Basically, you can understand that what I'm doing is I am postponing the decision of whether you're going to be convicted or not. You can think of it that way. I think in my mind, it makes it much clearer for you. If you live up to 100% of the conditions of supervision, and let me repeat that, 100% of the conditions of supervision. If you do that, then the case winds up being dismissed under Texas law. You were never convicted of the charge. A very beneficial program for you.
Agreed.
The conditions that you have to live up to are going to be read to you. You're going to sign them, and you will have a copy placed in your hands. Is that clear?
Yes, Your Honor.
Now, obviously, with the positives, there may be some negatives. And what we have is this. If you fail or refuse to live up to the conditions of supervision at 100%, then the state can ask me to bring you in after official notice for a hearing, at which the result may be, depending on the evidence and your history, the result could be that, first of all, I enter an adjudication of guilt, which is that I find you guilty at that point. And if that's the case, the punishment will be anywhere in the full range of punishment, meaning a fine $0 to $2,000 and jail from 0 days to 180 days. I beg your pardon, from a minimum 72 hours to 180 days. Is that clear?
It's very clear, Your Honor. Yes.
Very important that you understand that. Now what I'm looking at is the one document that does not have the identifying information. But the fact is, this whole document is your identification. It is in detail, your name, address, everything about you. Then you provided information on 3 different references who will always be able to find you. Did you ever serve in the military?
I did not.
Okay. And you are single, you have no dependents.
Correct.
All right. Now you're full-time employed. Where is that at?
It's called KM Builders. That's right off of Mainland Way
All
in
right.
Bandera.
And what is your total income?
It's between 50 to 60,000, depending on how good we are.
You're doing well, especially for a single young man.
I'm trying to do well.
Good. And you have a Ford Focus.
I do.
Someday if we have a chance, ask me and I'll tell you a little story about Focus. Sorry about that here. Excuse me just a second, Patty. Sorry about that. I had to take that call very quick. Okay. The next document we're going to show you, and it's been reloaded now, is called the plea agreement. That is the deal that you have made. There is a partial identifying information. It doesn't mention County Court 5, but that's okay. I can live with that. It's got your name, case number. Then you have the first 2 boxes on the official papers will be checkmarked. The first one talks about, guess what? We talked about it already, the right to remain silent. Then the second one will be checked off too, because you are a U.S. citizen. Now, Mr. Sanchez, you and Mr. Garfola have already reviewed these 5 checkmarked declarations. Is that correct?
That's correct, Your Honor.
Mr. Garfola, you have any questions about this section?
Not at this moment. I do not.
All right. Then you have the state has some motions.
Yes, Your
State?
Honor. The state moves to waive and abandon the extreme intoxication enhancement, and the state moves to proceed on an unenhanced DWI.
Okay.
We have no
Defense?
objections.
No.
We have no
objection
objections,
from
Your
defense?
Honor.
That last box right there will be, I'll have it marked that the motion is granted. Mr. Garfola, you now officially charged only with DWI first, not with the extreme intoxication, DWI with blood alcohol content 0.15 or higher. So officially at this time, sir, what is your plea?
Guilty.
You give it another try, sir. Look at the paperwork at the bottom there.
Oh, no, no contest.
Okay. The court accepts your plea of no contest. Let me explain briefly. The court takes this as a guilty plea, but there are specific reasons to protect you why your client has insisted on nolo contendere, and it is important. But it is, in essence, a guilty plea, okay? I do order you to come into the offices of County Court at Law Number 5. I want you to come in so that your thumbprint can be placed on the documents in this case as required by law. You understand?
I do.
The offices, you can always come in through the courtroom. If it's locked or you can't find it, you come around through the hallway in the back of the courtroom. And it's once you're in the hallway and back, it's real easy to find it, okay?
Okay.
All right. Sir, I find that there is sufficient evidence to find you guilty, including your own plea. But I do not find you guilty. In fact, I am granting you the deferred adjudication that you have agreed to, your agreement. It is 12 months of deferred adjudication. You will be fined and have to pay $500. You will perform 48 hours of community service restitution. Your supervisory fee, well, there's got to be more than that. All right, I need you to, in good faith, enroll in and complete the DWI education program, the DWI Victim Impact Panel. You'll submit to a TAP evaluation and follow the recommendations. Your supervisory fee will be $56 a month. Mr. Garofalo, do you have any questions?
I do not. It's all straight and forward.
I think so too, but it's important that I ask you to make sure if you do have a question, sometimes you have somebody that has a question or two, then this is the best time to ask it and answer it. All right, Mr. Sanchez, any questions?
Yes, Judge. I would ask the court if the court would entertain early termination if Mr. Garofalo finishes everything either within 3 months or 6 months.
Once he completes everything, bring your motion. I will give it consideration. The answer to your question is I will entertain it. I'm not going to tell you that I'll grant it. I'll see how he does in performance. Mr. Garofalo, you know, you've been blessed to have had some good representation, and you've got a darn good little job for a single fella with no obligations. Things are going good for you. The worst thing can happen to you now is you get drinking and driving and you go out and kill somebody. Think about that. You're looking at a maximum right now of 20 years in prison. How old are you right now?
36.
36. Add 20, you're looking at 56. The flower of your prime would be spent in prison. It could be. I would highly recommend to you that, first of all, you don't drink and drive. And secondly, give some thought to just how important is alcohol in your life. I will tell you that I've got 5 first cousins, the children of my aunts, that are dead because of alcohol. Not a pretty thing. You hopefully will give some serious thought to getting out of that temptation and better than that, getting away from that lifestyle. You don't need that. You've got a lot going for you. All right?
Thank you.
You're welcome. Good luck to you.